Hi everyone, this is Mark and Sham from Chartergate Legal Services, and in this video we're going to be talking about the joint and several liability umbrella reforms, and with a particular view on the construction industry. Construction in particular, we're seeing a lot of myths out there in terms of how the legislation affects construction companies because they engage a lot of their labour on a self-employed basis. I think it's important we put together something for the construction industry so they can get a better handle on how the legislation affects them.
I think construction is quite a unique sector. It's had years of various different types of engagements that have sort of evolved over time depending on what regulations or legislations come in, and I think we probably go out and see quite a few construction clients that have a multitude or various different types of supply chains, and it's almost a case of it's following the herd to a particular type of engagement, but it doesn't necessarily mean that all of the engagements shift to a particular one. So it's a good spread of different types, which is quite interesting when we're looking at joint and several liability. And we've certainly seen clients that have had direct engagements, whether they're self-employed or PSCs or even employees. But alongside that, we've had clients that have almost set up a separate business to engage those individuals as well, or have a difference of both. And then I think something that Matt mentioned in another one of our videos, actually subcontracting out the entire labour to a supplier. So it's perhaps self-employed engagements that the construction company once had has gone directly over to a labour supplier to also supply those individuals on a self-employed basis. And then even more going wider than that, we have a few clients that are national now. So that initial drive to get the workers that are needed for a particular project out of their usual area has meant they've had to go to employment agencies to try and find that. And then that's when you start to lose that control of that supply chain. So this joint and several liability is going to be quite an interesting thing for construction companies, because not only will they have to look at it from their own risk perspective, but also how they can then manage that going forward and down the chain to protect themselves, but also protect that supply chain.
Okay, so let me pin you down, put you in the hot seat. What does it mean for construction?
Well, what it means for construction, I think the first thing they need to start to do is, and again, this is similar advice to what we've said to other people in the supply chain. The first thing they need to do is have a look at their supply chains, see what is actually there, whether that's direct engagements that they have, because as we've said in another video, even if it's a direct engagement with PSCs, a purported umbrella could materialise in that under a case 3 scenario. So understanding those supply chains is key and vital to the joint and several liability. And just to add to that is that, often it's rare, but what we do sometimes see is construction clients, the bulk of their business is construction, but every now and then you might get a client that actually supplies labour on a particular project. So if that's the case, could it be possible that particular supply becomes caught up in these umbrella arrangements, because for that particular project, all they are doing is supplying labour?
And so that would fall into the umbrella company arrangements, I suppose.
Certainly, it certainly could do.
So talk to me about how the purported umbrella companies and particular case 2 might fall into or be very relevant to the construction industry.
I think case 2 is probably the most relevant to the construction industry. And the reason for that is that a lot of construction companies saw the risk of direct engagements with self-employed individuals, and quite rightly at the time subcontracted that out to another party.
So it's like a 3-tier chain then. So construction company, labour provider, intermediary, whatever we want to call them, and then a self-employed subcontractor.
That's right. And then over the years, there's been some regulation and legislation that's come in to try and tackle that. You've mentioned it in another video, is the Section 44, the agency legislation has come in to tackle that. So what we're looking at there is if an individual personally provides services to a client in consequence of a contract between that client and a third person, so an agency or a labour supplier.
So the exact chain I've just described.
Then the labour provider has to operate PAYE on the payments to that individual. There is one exemption to that,
Yeah.
which is that if they can show that there's no supervision, direction, or control over the manner in which the work is done, then Section 44 wouldn't apply.
Okay.
And that test still exists today. But the key thing there is under Section 44, once a labour provider or supplier is in the chain,
Yeah.
it's their responsibility, it's
Okay.
their liability. So again, rightly so, construction companies subcontracting that labour to that party was great to do at that time because it protected them from any liability over employment status.
So they subcontracted the liability as well, really?
Indeed, they did, yes.
Okay. So what's JSL doing to that?
So JSL is actually dragging the client back in.
Okay.
So if there is a Section 44 issue, so if the labour supply cannot show that there's no supervision, direction, or control over the manner in which the individual does the work, and that results in a Section 44 liability,
Okay.
then that will actually also then drag in the end client into that same JSL liability. So there will be potentially a liability for the end client.
Okay, so we've got a scenario where, if I'm understanding this correctly, the SDC rules, as they're known, Section 44, still applies.
Mm-hmm.
But from April 2026, a construction company can still outsource the engagement of the labour, but they can't outsource the liability any longer.
That's right.
Okay. So it's big.
It is big. It is big. But it's still not wrong to subcontract that situation out because there's still some protections, other protections from employment tribunal claims.
Okay. Yeah.
All of those things are still subcontracted to that labour provider, but from a tax perspective, because of what is now this new deeming provision under the joint and several liability, it can and will drag in the end client. So in terms of trying to protect against that, again, similar sort of tip to what we've said in other videos is communication is key. So once you know exactly what's going on in your supply chain, you need to be speaking to those labour suppliers to see what the position is in terms of the supply that they are making into you. Mm-hmm. Having a look at their processes and procedures and seeing where you can help to shore that up.
Okay.
So again, it's about communicating with those labour suppliers.
Okay. I think it probably works the other way around as well. If I'm the construction business at the top of the chain, what's my labour supplier telling me about this legislation? How on top of this legislation are they? Do they understand the effect of this, and are they explaining that to me, and what changes are they going to make to protect the client in the same manner they were protecting them before this legislation?
Yes, I mean that's actually a big part of it because what this is going to involve is every party in the chain communicating, working together to see what impact there is, and actually what tends to happen when there's sort of big changes, wholesale changes such as this, is you get loads of comments made in the sector of they're supplying a service, so none of this applies. We saw that with the domestic reverse charge for VAT in construction. Ultimately, what will come to light is actually what is the supply?
Okay.
Is it actually construction or is it something else? Who has control over that project? Who decides how many people come up? And those things are going to be vital to determining this. And actually, if ultimately all that's happening is a supply of labour, the client will be dragged in, regardless of what has been said to them by their suppliers in the past.
Okay. So if I'm summing up and I'm a construction business, definitely don't have your head in the sand. Definitely don't assume because the individuals are self-employed that they can't fall within this legislation. Review your supply chains. Understand how it can affect you where you might be doing jobs that are simply providing labour, and make sure that your suppliers are looking after you and understanding the legislation, but also review all your engagements and decide whether they're still fit for purpose now that the liability is potentially shifting to them as well.
Yes, I think that's a good summary, and I think that last point is key as well. In that, I guess historically it's been okay to rely on advice provided by your suppliers, but now to get that independent advice that is specific to your supply chains is probably more vital than it has ever been.
Okay. Anything else to add, Shan?
Yeah, I think that covers everything.
Okay, thank you.